Appeal number 61, the people of the state of New York versus Jamar Bethune. Good afternoon, Counsel.
Good afternoon, Your Honor. May it please the Court, my name is Ryan Blanche, and I represent the appellant Jamar Bethune in this matter. I would request to reserve 3 minutes for rebuttal.
You may have 3 minutes, sir.
Thank you. As this Court is aware, Jamar Bethune was convicted of murder and sentenced to 25 years to life in a trial in which his only defense was that the gun had discharged accidentally or unintentionally. According to the certified transcript that we requested for review on appeal, the trial judge instructed the jury at certain portions that they could issue a guilty verdict in the event that they found that the shooting was unintentional.
Counsel, what standard would you have us apply for when a reconstruction hearing is required?
I think that an error of this type would satisfy just about any standard, whether we're talking about abuse of discretion or clearly erroneous. If this court were to find that the trial court judge was clearly erroneous.
Well, that's our review standard, but what facts and circumstances would give rise to the need for a hearing?
For a need for a hearing to settle the record? Well, the circumstances giving rise to the need to settle the record are that we received a certified transcript in which the trial court judge gave a jury charge that was...
Understood. And then you came before the judge and you had a proceeding and there was a transcript put in, there was a letter and materials from the people. And my understanding is now you're saying that wasn't enough.
That's absolutely correct.
So what standard do we apply to say what is enough?
Well, what the courts have held, if I may quote in both Santorelli and Jones and Michalek, regardless of what case we look at, they talk about independent recollection. In some cases, the court talk about a definite recollection. In other cases, it's a vivid recollection. If I may quote from the transcript.
So what does the record show here about the judge's recollection? As I read it, the judge in making his determination here referred to his recollection.
I would respectfully disagree, Your Honor. I believe the judge refers to Santorelli, and one of the factors Santorelli cites is that if there's recollection, the court may find. However, in the transcript, the judge swiftly departs from that and says, quote, "It just doesn't make any sense that the court should say unintentionally." And then in the same context, say intentional.
Well,
it just doesn't make any sense.
Couldn't that also, I mean, I think we're looking at context here, and would you agree that context is a fair consideration as well?
Yes,
Okay.
Your Honor, I would say
Okay.
it's one consideration, but I think if that's
Okay.
all we rely upon.
Well, no. We may or may not, but that's not what I'm suggesting. What I'm saying is that the court never said, "I don't recall," but let's look at the context. So those comments could have been additional, basically saying, looking at Santorelli, saying if there's independent recollection, that we don't need a hearing. That says to me that he's indicating that there was some independent recollection. And by the way, it doesn't make any sense in the context. Isn't that a perfectly legitimate reading of the record?
Respectfully, I believe it might be a legitimate or a fair reading, but it's also a strained analysis of the record. Because here we have a judge that's clearly pointing out, because I believe prior to the judge pointing that out, the prosecutor starts by saying, according to Santorelli, as long as the court recalls what happens, that's enough. Mm-hmm. So the judge almost has to echo that, because that is what Santorelli relies upon.
Aren't you really saying, in this case, I think the phrase is vivid recollection that's being used, and he didn't have any notes, the judge, right? That's correct. There were no reference to notes. And it's tough. I agree with Judge Stein. It's kind of tough to read this transcript and decide exactly where the judge is coming down on the whole question of what his recollection is. I suppose your point is that his recollection of what he normally does, not what he did in this particular circumstance. Is that what you're arguing to us?
I would view it a little bit differently. I think that the reason why the judge cannot refer to a specific, vivid, or independent recollection of whether he said unintentionally or intentionally is that in the event he said unintentionally, accidentally instead of intentionally, it didn't go noticed at the time.
What about the fact,
So it's impossible to recall something that goes unnoticed. It's
what about the fact that counsel also said the same thing twice, according to the original transcript?
Yeah, yes, Your Honor.
How can you I mean, I guess the question I'm asking is, if the context makes it really strong that there was a consistent typographical error, can't that override the judge's specific recollection in terms of whether there needs to be a hearing or not? Isn't that something that could go into the judge's discretion?
I don't think so, Your Honor, no, because that would be an attempt to replace recollection with supposition, because that's the prosecution's argument, is that if we look at everything, it's more likely than not this was an innocent mistake. But we could argue the other side as well. It's just as likely that if there is a consistent mistake by a court
The problem
reporter.
is you had the definition of intent that was given, and rather than an intentional, it said conscious, objective, or purpose in the same paragraph during the use of the mistaken word. And that would seem to be directly contrary to your argument if you look at the whole context. On top of, the way I understand it, the word unintentional was used 5 separate times and out of maybe 300 words that were given at that particular point.
If I'm understanding, Your Honor, I believe the point that you're making is that because there's other instances in the supplemental instruction in which that mistake is not made, that it becomes clear that that wasn't the intention.
No, what I'm saying is that intent obviously is a question in this case. I think that's a fair argument on your part, and that and the consciousness of intent, of a conscious objective or purpose, was clearly charged to the jury. So the court was not charging them on saying that intent was unintentional. That was what, he wasn't doing it. That was a mistake. Let's assume
Correct,
that
a
was given.
mistake.
And that was a mistake, and the rest of the charge clarified that and seemed to make it clear that intent required a conscious objective or purpose. That's quoting from the charge, that's what he gave. So doesn't that solve the problem, or is a mistake dispositive?
I believe in this situation, a mistake is dispositive, especially where you have a jury that is already expressing confusion about the intent element prior to the mistake being made.
Counsel, you're
So
running
I'm
out of.
having a little difficulty envisioning, from a practical point of view, what would be the purpose of the hearing?
So the purpose
You
of the
contradict
hearing-
the stenographer, challenge the judge's recollection? What would be the purpose?
Here we have 2 certified transcripts by the same stenographer. And interestingly, importantly, I would add, that no one who was at this hearing to settle the record, other than the judge, had participated in the trial. Our client wasn't permitted to be there. Trial prosecution was not there. Defense counsel at trial was not there. And the
So what's going to happen at the hearing? You wanted the stenographer to be called and say, yes, the second set is the correct set?
I think what we want to understand is how is it that 5 years later we have this 2 very different transcripts? When we ordered our transcript, we just asked for a certified transcript. The second transcript was produced under a very different request that we should be able to inquire about. The prosecution called ex parte the stenographer, which maybe by itself is not an ethical
If the people had submitted an affidavit from the stenographer explaining that, do you still need a hearing?
I think it would depend on what the affidavit said, yes.
Well, let's say it says exactly what the ADA said.
Well, the ADA said in a footnote
I
that,
had this conversation, the stenographer went back, looked at it, realized it's a mistake, and has now reissued a corrected version. And if that's what the stenographer says, do you still need a hearing?
we for sure need a hearing in that situation.
Why?
Because if this is a murder case, it's very important, and you're a stenographer who's receiving a phone call from a prosecutor in a murder case saying, I think, in a very leading way, I think there are mistakes in the transcript. So this isn't a request to fix the whole transcript and check it. The mistakes are pointed out. The prosecution admits that in their footnotes, that there's 5 mistakes. We think that they're mistakes. Take a look.
But what we do have here is the affidavit of the prosecutor saying that she checked her notes and that it was improperly transcribed. So it's not just, we have that additional fact. It's not just, well, yeah, the prosecutor called and suggested that maybe there was an error here, and I agree, you know, he or she was probably correct. So why isn't that enough? Or if that's what the steno said, would that be enough in an affidavit?
Well, for one, I would argue, Your Honor, that to properly recertify an entire transcript, you have to go through the honest process as a stenographer to certify the entire transcript. So when a prosecutor calls and says, these are 5 problematic errors, these are mistakes, and other mistakes remain.
Well,
in
did
the new
defense
transcript.
counsel ever object and say, I want to, you know, inquire about other errors? I mean, there were obviously some other errors, as I read it.
Correct.
Clearly. But were those material errors? Did the defense ever say, well, wait a minute, I want to ask about these errors?
And that's a great point. We won't know whether or not that was an error made by the judge, or that's another type of ground.
No, I know, but this is sort of, in a way, a preservation question,
Right.
you know.
Did you make any effort to contact trial counsel?
We did make effort. My office made effort, not me individually. Trial counsel, I believe, no longer works at that office.
Counsel, you started out by saying that this is important because the judge incorrectly instructed the jury, said unintentional. Is that right?
Correct.
Okay. Was there an objection at trial by trial counsel when the court instructed the jury with the word unintentional?
I don't believe there was an
So
objection.
3 times there's no objection.
I believe that's correct.
Okay, so is that at least something that we can take into account in deciding no hearing is necessary because counsel would have objected if the word unintentional had been said 3 times in an instruction?
I understand Your Honor's point, and it's an important point, but I would submit that in a murder case involving the defendant's only defense and his due process rights, that the fact that counsel was not attentive to an issue such as this would not.
So do we have to view it through an ineffective assistance lens? Is the actual error preserved? There's no objection?
I believe it's per se ineffective assistance if that error is made and there's no objection made.
Thank you, counsel. Counsel?
Good afternoon, Your Honors.
Good afternoon.
Jody Mandel for the Office of the Kings County District Attorney. The standard to be applied here is whether the Supreme Court properly exercised its discretion in determining that there had been a mistranscription rather than misspeakings when the word unintentional appeared 5 times, spoken by 2 different people, in place of the word intentional in the supplemental charge.
Did we say in Santorelli that a vivid recollection or any kind of recollection was an absolute requirement, or did we point to the fact that that existed in that case?
The court did not say a vivid recollection was required in Santorelli. The court in Santorelli happened to have had a vivid recollection, and there, the court also did not have any notes by a court reporter.
And what if
So
the
there's-
judge was no longer available and you could never have a vivid recollection, you could never resettle a transcript?
That's correct, Your Honor. And the court here had many other things before it. And, you know, the proceeding in Santorelli was whether the defendant had waived his ante marchi rights. So it was a crucial part at the beginning of a trial that a court might be expected to remember. But 5 years later, and just as an aside, the 5 years that keeps getting mentioned here, the four-person order granting the defendant the minutes in this case was in 2009. The defendant didn't file his brief until 2014. So the 5 years was the delay on the defense, not on anyone else's part. And so you wouldn't expect a court to have a vivid recollection of what could have been a misspeaking.
Is it a better practice for the people to have submitted an affidavit from the stenographer explaining that she had reviewed the notes and did indeed recognize that it was an error, and then attaching to that the certification for the new pages as corrected?
That could have happened in this case, and in fact, at the proceeding before Judge Tomei, I offered to bring in an affidavit from the court reporter, but the judge deemed that it wasn't necessary. And the fact is, better practice is not the issue before the court. The issue before the court is, did the court abuse its discretion here?
What's the force and effect of the certification that the stenographer executes?
Well, stenographers are officers of the court. They take a constitutional oath of office. And they are required by the judiciary law to certify transcripts as true and correct. And so to say that we wanted to explore why there's one transcript that's certified and another transcript that's certified. Well, the first transcript was done all at once pursuant to the court's four-person order in this case. And the fact is, we all know that there are mistranscriptions in transcripts. And in fact, in this case, there were other mistranscriptions. A couple of times, the shoe box where the gun and the bullets were kept is called a show box. But the fact is, many times, mistranscriptions don't impact the case.
If it was only one time, and it was only the judge, should there have been a hearing? Does that change the whole context?
It might weigh in favor, but the fact is here.
And at the hearing, who's going to appear, or what evidence is going to be submitted to the judge to trigger a memory? If the judge sees the one word and says, I can't immediately recollect.
Yeah, I'm not sure what form that hearing would take, because if the judge doesn't remember misspeaking, it's highly unlikely that the prosecutor or the defense attorney would remember that.
Let
And
me
the
ask
fact-
this. Let's assume that the word unintentional was said, all right? I understand your argument, it wasn't, but let's just assume for a moment that it was said, and the transcript that showed that was correct, that charge was given. What would you say then to defendant's argument that the court charge in essence eliminated the people's burden of proof?
Okay, I'd say a couple of things.
Go ahead.
First, I'd say that that issue is entirely unpreserved, so it's outside the scope of review of this court, because there was no objection. Second, I would say that this was the supplemental charge. The final charge to the jury, the lengthy final charge to the jury in this case was flawless, and the defendant has never made any claim about that charge. So, and any confusion that the jury had at the end of the case was actually after the final charge and before this supplemental charge.
And was it
So-
after they had already found him guilty on count one?
Yes, yes. And they have.
So you're
and-
saying that charge, I'm asking you a straightforward question, would it change the people's burden of proof if that was the charge that was given?
No, because this court has
You're
held.
saying if you use the word unintentional instead of intentional, that doesn't change the burden of proof for the people?
As long as the charge as a whole conveys the correct legal standards, it doesn't change the burden of proof. And particularly here, one misspeaking of a word, which I'm
I
not
understand that
conceding.
argument. That's a reasonable argument you're making. I totally understand that. What I'm asking you, though, if the wrong charge was given, is it a change in the burden of proof? And you're telling me, no, it's not.
No, because the court was clear on the charge on who had the burden of proof here, and it was clear on what the elements of murder were in its final charge.
I see.
And in fact, even if this was a misspeaking, the court went on to give an expanded intent charge and repeated the fact that intent is required. Intent is required. So there was no error in the charge as a whole here. And the court, I just want to go back through there are 5 reasons why the court exercised its discretion properly in not holding a hearing.
Just ask you, if you had gone to the stenographer and the stenographer says, no, I don't remember, but no, that's what I put in my notes. You're right, it doesn't look right, but that's what I put in my notes.
That would have been a much harder question for the court.
But let's say you then went to the judge and you made the arguments about the context, and the judge says, I don't have a recollection, but it makes no sense in this context. What do you do?
It's still, ultimately, the judge is the final arbiter of the record. And we have to rely on the judge's ability and his responsibility to submit a correct record to the appellate court. So it would have been a harder question than the one we have here.
Even with the stenographer saying, yes, that my notes indicate that that's exactly what I wrote, and the original version is the version that I still certify.
Yes. I mean, it's not clear, in the Alomar case, there is another case decided, Morales, within that case. In that case, the court did have a hearing, and the court reporter just said that it was a mistake in the transcript.
Well, when would a hearing be required?
That's within the court's discretion.
Well, but So whatever I mean, there is an abuse of discretion standard. So
Yes.
when, I guess my question is, when would it be an abuse of discretion for the court not to hold a hearing?
Well, let's say, I mean, there are reconstruction hearings when an entire voir dire the notes for an entire voir dire are missing, or a suppression hearing, like in some of the cases cited in
So
both
only
of our briefs.
when the notes, when it's missing completely?
No, there may be situations where, let's say, the court reporter is ambivalent about what her notes said or what they didn't say. Or in one of the cases, the defense attorney submitted an affidavit. The trial attorney said, I absolutely did not say those things, and the defendant submits an affidavit, I didn't say those things, and then the prosecutor is saying the opposite.
But counsel,
There are
isn't
situations.
it the standard, it seems to me, if you look at Santarelli, and you put aside, do you need a vivid recollection or all the other things, the bottom line on Santarelli, it seems to me, is the record's adequate for the judge to reconstruct what occurred? And the abuse of discretion seems to me, not having a hearing, would be, without a hearing, the record is inadequate for the judge to reconstruct. Isn't that a simple reading of Santarelli?
Yes, I would agree with that, Your Honor. And so here, there was more than adequate ground for the court to decide that these were mistranscriptions and not misspeakings. It was entirely implausible that it happened 5 times with 2 different people. There were no objections made. The original notes of the court reporter supported the fact that she had made a mistranscription. The court had some recollection of the proceedings, and the context of these errors did not support at all that they were misspeakings. And I would just like to say that the remedy suggested by my adversary is not the proper remedy here. Even if this court were to think that a hearing should have been more full, then the court would send the case back to have a hearing, not decide the appeal on the erroneous transcript.
Thank you, counsel.
Thank you.
Mr. Branch?
Santarelli makes it very clear that they're relying upon, quote, a very definite recollection by the trial court judge of what transpired.
In that case, though, and it can't be the standard where you could have a judge who's no longer available, that you can never resettle a transcript again. And
don't
I
think
think
that's true.
Santarelli, to me, stands for, it seems that the record needs to be adequate for the trial judge to reconstruct what happened. And vivid recollection gets you, a certain way. An affidavit from the court reporter may get you a certain distance in that. But what we're looking at is the overall record in front of the trial judge resettling the transcript to determine if it was adequate to make the determination.
I would agree with that. Every case that I have looked at talks about some form of vivid or independent recollection.
Is there a court of appeals case that makes that a requirement?
All the decisions seem to hinge on it. Now, is it possible we could have a different case where there is no recollection, but the record is substantial enough that it can be made without that? Sure, but this is not that case. In this case, the only thing we have in the record is an effort in hindsight to apply logic to a situation to guess at what probably happened. It is just as likely that that same court reporter heard the judge say unintentional once, and he did say it perhaps, and then assigned that same mistake to the defense attorney at a different time. The point is, we'll never know, and this is not something that's about.
So if we'll never know, what's the point of the hearing? Aren't you then really saying you got to have a new trial?
The only way, Your Honor, that we could have known would be at the time to talk to the stenographer and ask how that conversation went, what her process was in correcting this already certified record. The reason why I say that.
Well, couldn't that still lead to more questions and a credibility determination? I mean, it's pretty rare in courts for there to be something so absolutely definitive that there's no question at all about it. I mean, that's kind of what courts are about.
That's true, but then we'd be back to Judge Tomei looking at the record that's produced after the questions, and then we'd be having a different argument about whether or not, in light of the testimony or in light of the affidavit, if there were an affidavit, I submit it would not be enough to merely recount the language that she checked her notes and this is correct, we would need to explore.
I guess my question is, what could she have said to have turned this around?
I think there would have been a lot of back and forth about her process, because she certified it first time, and presumably, she went through that same process the first time. The second time.
So what you're saying is that maybe the testimony would have shown that she wasn't as careful about it, or that she made some assumptions?
Perhaps the testimony would have shown that she went through the same analysis, given some ambiguity in her notes, that the trial court judge and the prosecutor are applying now.
And if that's,
It doesn't make sense in the
So
prosecutor.
since the ADA didn't put in an affidavit from her, could defense counsel could have gone to her and put in an affidavit from her?
Well, we requested to speak to her at the hearing, not
Yes.
ex parte.
No, I understand that, but I'm saying, is there anything that foreclosed you, prohibited you, made it impossible for you to get an affidavit from her?
I think, given the fact that the prosecution had already stated that she's corrected the record, I think she would be a somewhat less than friendly witness at that time. And I think it would require a lot of hard questioning where a prosecutor should be there as well.
Thank you.
Thank you, counsel.